Hello and welcome to Legal Candy. I am attorney Candice Colucci and I am here today with Darby M, our legal student who is here to help us with all of our legalese and to flesh out any legal issues or legal concepts that we talk about today. In each episode, we are breaking down the complex legal topics into bite-sized, easy-to-digest conversations. Now, continuing from last week, we were delving into the gripping case that's making headlines, the Maya Kowalski case. If you guys are aware of it, there is a hot streaming Netflix documentary called Take Care of Maya. This is a very emotional subject. It also deals with, I want to give you guys a disclaimer, we'll be dealing with unfortunate suicide. We'll talk a little bit about that. But this was one of those just gripping documentary that has opened everyone's eyes to what has taken place with this horrible case in regards to the health issues and the ultimate outcome. So this is, we're going to be really, I'll give you guys a little brief overview of what we've already talked about, because today's idea is to really kind of go into what took place with this case on the legal side, what happened with the actual trial. So get ready for a flavorful journey through the legal intricacies surrounding this case, from the latest developments to the timeless legal principles. We're here to provide you with a delicious blend of legal knowledge, so grab your legal candy, sit back, and join us while we continue to unravel the complexity of the Maya Kowalski case in a way that's both entertaining and informing. Welcome to Legal Candy, where law meets sweetness. Oh, I just love it. Oh yeah. We were talking about, what is it? It's
ASMR.
ASMR. Okay, so Darby was just telling me a little bit about this whole entire, where they're with their voices and they're making little sounds. Here's my pen clicking.
Welcome to
the show. So we will give you a little bit of the backstory. So I'll give you guys my legal disclaimer that we have to do before we delve into our legal confections. A quick reminder that the information provided is a general informational purposes only and should not be construed as legal advice. It is not intended to substitute for or replace professional legal advice tailored to your specific situation or needs. If you require the assistance of legal counsel, please reach out to a qualified attorney. Although I am qualified, I'm not technically your attorney, and this doesn't create an attorney-client privilege or any kind of relationship. But please feel free to reach out. You can reach out to our office, Colucci Law Group. Our phone number is 727-733-9438, or shoot us an email at office@Colucci, COLUCCI, lawgroup.com, and send us any questions that you have. So before we jump into going over what took place with the Maya Kowalski case, we had a question. We had several questions, but we will address one of the a twofold question that came from one of our viewers. It's at Charles Quick 3091. We appreciated the question. It was very on point, and this has to do with the George Floyd concepts that we were going over. We were talking about the George Floyd trial and his unfortunate murder and what that looked like when they actually turned around. And that, remember George Floyd, that sparked all of the movements of the Black Lives Matter movement. And then what ended up happening was the officer was put on trial for his murder and was convicted of that murder. Him and other officers were also convicted in their wrongdoings. So here's the question. Not trying to be mean, however, I have a couple of questions. I always love when someone starts off not trying to be mean. It's like, I'm not really trying, but it may come off mean. But this is one where he says that, but then when he talks about it, he doesn't come off mean. So
no, I think it's just a really controversial case, and I don't think anyone wants the light on them that they stand for one side more than the other, or they stand for the corruption of one person over another.
Exactly, yeah, for sure. It was very polarizing. Obviously, it was definitely. So the question is, if the guy was fired, he's meaning the head officer. If the officer was fired by the department, why would that be important? Wouldn't that be important in proving his guilt of murder in his trial? His lawyer is going to say that the department was trying to distance himself from him and did not prove anything. Okay, so this is because we talked about, we've talked a little bit about, and we want to continue going into what the rules of evidence. One of my favorite concepts that I think most people are not aware of is the way a jury trial works. And so there are certain things that are allowed to come into a jury trial, and there are certain things that are not allowed to come in. And giving you an overarching, because we're going to talk about this with the Maya Kowalski, and we're going to talk about it in future trials that we talk about, is that to give you an idea of how evidence works in a trial. And the fact that I'm Stetson trial trained, so I am a trial litigator. I have been trained by the best trial litigators in the country. I graduated from Stetson Law, which is the #1 trial advocacy team, and I was on that team, and so I have been trained by the best. And so when I first was learning how trial works, this was one of the best explanations I ever got. Is the way trial works is all of the evidence gets put together, and then it has to be determined, is it admissible for trial? And really, when you're looking at it, one of the things that we kind of always said is, if evidence makes you look too guilty or liable, it's not coming in. And evidence that makes you too good, like that you didn't do it, is usually not coming in. So if anything's polarizing in one way or the other, it usually doesn't end up coming in.
Now, why is this a goal for the jury? Like, what is this creating for them? Like, why can't it be just this nail in the coffin kind of evidence?
Everything comes in.
Yeah.
Why can't everything come in?
Yeah.
It's because you have a constitutional right to a fair trial. And what a fair trial means is that when the jury sits down to hear your trial day one, all the evidence that come in should be very relevant to what you're there for. So if you're being charged with a crime like murder for this one incident that happens on this one night, so if this one night you're being charged that they believe that you came and you shot this person, the jury should only hear the evidence that's relevant to that night.
Okay.
They shouldn't hear anything else outside of that night. So those are some of the things that we're looking for. So let's just say that you're being charged because you have a right to a fair trial and an impartial jury that's looking at you and saying, on that night, did you create that murder? So let me tell you, so if you were sitting there and you were a jury and you were hearing a trial about somebody who's been tried, who's been charged with murder, and if at the very beginning of the trial you found out that he has been charged before with murder of somebody different,
oh, I'm biased.
You're biased, right? At the very beginning, you're like, listen, it doesn't happen twice in your life, kiddo.
It quacks like a duck. It
Exactly.
Looks like a duck.
Exactly. So that's really what it is. The idea is to keep this jury impartial so you get a fair trial, especially if you're in criminal, but also if you're in a civil trial. So remember, criminal, you have the penalties of potentially going to jail. In civil trials, that there's no penalties of jail. These are all going to be usually about money. The liability will come down to money for those things. Mm-hmm. So in both of those type of cases, the evidence is exactly what can come in and can't come in. The evidence rules are the same. So there's certain evidence rules we have to follow. Say, can it come in or can it not come in? But that's a good example of letting you know is like you would start already being biased if I told you these things. Or the same thing, like let's say someone's on trial for rape. If you found out that he had been convicted of rape before, now if he's been convicted, it's going to make you biased, right?
Mm-hmm.
Yeah.
For sure.
Well,
I'm human.
Yeah. But the way the rule looks at that is they say, now, if we're talking about a conviction where it's a felony conviction, we believe those should come in because those are convictions. Because that means another jury with this high standard has already charged you and found you guilty of it. So that should be okay to come in. So anything of your past acts, what can come in? We call it bad guy evidence, character evidence. Things that are convictions for all felonies are allowed to come in, and any crime of dishonesty is allowed to come in because they've also determined over time that if you've lied before and you've been convicted of theft, that's considered dishonesty, fraud, that's considered dishonesty, writing bad checks, that's considered dishonesty, that a jury should hear that because that goes to your credibility. That goes to your credibility if you're going to tell the truth on the stand. So those are some of those rules. So when we go back to this question of why does that not come in this instance, now remember, this is one of the biggest fights we have as trial attorneys. We fight for a while over what evidence can come in and can't come in. We fight before trial, and then a lot of times we fight right in trial. So when you hear those words objection, we're objecting to things that are being said or evidence that's coming in that we believe at that time should not come in or not. You can address them before trial, which is hard to do with everything, but the big things you'll address before trial. But most of the other stuff we take we take it up right in front of you, in front of the jury, and right in front of that judge, where we literally are saying objection relevant, meaning we're saying we object to that evidence coming in because we believe that it's not relevant.
And this is to keep everyone on like a level playing field. That's why you're supposed to know about what evidence is being brought before trial starts.
Yep. Okay. You have to know. So we're prepared. We're prepared to either potentially, we want to be prepared to have a counter argument to that evidence before it's brought in. But we also may potentially want to try to, called motion in limine is what we call it before trial. We want to motion in limine it out so we know it's not coming in at all, especially if it's something large. Okay. If not, we want to be prepared during trial that we know it's coming in and we're going to try to object to keep it out. Because we can object during the trial and the judge can, this is where most trials are won and lost. It's this evidence objections. So we could literally, you could try to put something in. You can go, I want to enter this into evidence. And I could object and say, no, I object. I'm objecting to relevance. I'm objecting to the fact that it's improper character evidence. And I'm objecting that it's unfairly prejudicial. And a judge could say, yep, I agree with that. That evidence isn't coming in. And now all of a sudden the other side's like, oh my God, what do I do? I was relying on that. That's why there's so much stuff happening in the background of a jury trial, which is why I was so obsessed with learning about it, and why one of my thrills in life is literally a jury trial, is because it is the most intricate game you've ever played, with the stakes of people's lives on the line for it. And so the better you're prepared and know how to play it, the better you can save people's lives and change people's lives, which is why I wanted to be trained and why I sought after Stetson, and I'm always grateful to Stetson for everything they taught us. We had some great professors over there and a great trial team program. So back to that question. The question will come down to, so that information will say, so if all of a sudden what would have happened is they would have you would have had the prosecutors wanting to bring that in. Of course the prosecutors want to bring it in. If you're going to try this officer for murder, wouldn't you want to bring in the fact that the police department had already fired him because the police department obviously possibly believed he had done something inappropriately. So they fired him for it.
Yeah. They think it didn't follow line with their policies. And
yes.
And this, I think, goes to what you're talking about with this credibility, and that's why it would want to be brought in.
Yeah. So why it doesn't get brought in. So the prosecutor would have said, we want it in. Of course, we want it in. It's going to help prove that he's guilty. Now, the defense, the attorneys for this officer are going to heavily argue that it shouldn't come in. The first arguments they would have made is they would have said it's not relevant. They would have said it's not relevant that what happened afterwards. We're here to prove that on this day in time, did that officer violate his obligations, and that led to the death of this person. That's what they're trying to prove. So a lot of times anything that happens after the actual moment of that crime, that alleged crime, is usually not relevant to your criminal trial, because what happens afterwards is not going, it could be probative, it could be relevant to prove, but it's what's problem is it becomes very prejudicial. So the next question is, we always say, is something relevant or not? And even if it's relevant, if it's prejudicial, which means so hurtful to the person that it's being used against, then it shouldn't come in because it's too bad. So then that's really what ends up happening, is that the court will literally analyze and we weigh it out. And that's how intricate these evidence rules can be, and they can change everything, is because the question really comes down to, yes, we can see relevance in that, but is the probative value of that outweighed by the prejudicial value? Which it is.
Like a balancing act.
Balancing act, yeah, it is. It's going to make him look more guilty, and it really takes away from the jury's obligation, which is to determine on that day and time, did he do it? Because what you're really looking at is the standard. He wasn't found guilty by a jury trial. All that happened is he was fired from the department, and there could have been a lot of reasons why they fired him. First of all, whether he was found guilty or not, ultimately, the department had to fire him. Like, they had to get rid of him, because if not, we know now, okay, and they predicted it then, they would have burnt that whole city to the ground, including probably the police department at that. They would have started there had he still been. He wouldn't have been able to be on the streets. I don't know what they would have done with him. They'd have to lock him in some kind of cage. I mean, and have him do desk work from a jail cell or something like that. I mean, that's really what would have happened, unfortunately. He would have had to be he had to have armed guards. So they wanted to distance themselves, which is what he says there. This question says, yes, they wanted to distance themselves. That's why it's not admissible. It's not credible enough. Just because they fired him, we don't know why they fired him. What are the standards of firing somebody? You can fire anybody at will. You can fire anybody in most states. You can just decide to get rid of them. So if that came in, it would start off a jury going, well, if the police department got rid of him, he obviously did this.
It would skew their thinking.
Yeah. They would no longer they would have a bias to him at the very beginning that would start off with going, I don't really want to hear the rest of the evidence. I already know. I heard what I need to know.
I made it up.
Yeah. So that's really the reason why that wouldn't come in. So it doesn't meet the evidence rule. So yes, it's relevant, but it's so unfairly prejudicial because it doesn't have the high standard of reliability. We don't know why the police department did that, and it would start off with the jury being biased. So that's that question. So the next question is, second question. What does a civil suit have to do with proving his guilt, as the requirements are a lot different? Now, I'm not defending the guy. I'm curious as to why either of these points would be important for proving he murdered somebody. Okay, so we briefly touched on before when we were talking about this is the difference between that criminal and that civil trial. So you've got the criminal trial, which are going to be charges brought by a state or federal prosecutor. So those are criminal charges where you can be looking at jail sentence time. But a civil trial is when two parties, two people, two individual people, two businesses, the government is not involved at all in a civil trial. And between those two people, they're fighting over potential liability. They're saying, you did this to me, and the result should be you should have to potentially pay me for my damages. It's all about usually money when it comes to civil trials. In a civil trial, nobody's going to jail. Nothing to do with the state and nothing to do with the federal prosecutors. So we're going to go to our first break. Stay tuned. We'll talk more about what the civil versus criminal, and then we'll get into the facts of what took place during the trial of Maya Kowalski. Welcome back to Legal Candy. So let's keep on talking about the trial requirements. So we've got the two different types of trials. We have the criminal trial, civil trial. We were just talking about criminal. You can potentially go to jail. The state brings it, or the federal government brings those charges against you. And in civil, you have two parties, two people, or two companies fighting. The big difference between the two, not just that you can go to jail or not go to jail, but it's something called the burden of proof. The burden means what is the level of real evidence that has to be proved in order to find that person guilty or liable. So in a criminal case, the burden is high. You know what the burden is?
The burden, yes. But I would like to make this point, though. Yeah. Doesn't the burden of proof transfer depending on a civil and criminal case? Like whether it's the defendant or the prosecutors that have the burden of proof to find someone guilty.
So in both of those cases, a criminal and a civil trial, the burden of proof starts with the person who's bringing the case. So in a criminal case, it would be the state or the federal government. They have the burden. They start off with the burden. That means they're the ones with the responsibility. Hey, you brought that here. You better do something about it. And in a civil case, the plaintiff, that's where you see the word plaintiff. That would be whoever is the one who's filing the lawsuit. They start with the burden of proof. Now, there are certain defenses that can be raised, like self-defense, where it shifts the burden, which just means now the burden's on the other party to now prove something. Because in a criminal trial, you've ever heard that before. In a criminal case, the defendant does not have an obligation to prove anything.
Yes.
Right? Because they're not the one who brought the case. Unless they put forth a certain defense, like the self-defense, where the burden changes and now they have an obligation to prove something.
Now, the burden of proof is beyond reasonable doubt.
In criminal. Yeah, so in a criminal case, the burden of proof is beyond all reasonable doubt. That's what you've heard before. If you've ever watched a trial or anything like that, that's what you've heard. That means that when the jury sits down and you've been charged with murder, the question for the jury really comes down to, did the state or federal government prove all these elements of a crime, of murder, beyond all reasonable doubt? That is the highest standard, because think about it. The results are you're going to jail for life. Like that's the reason why it's a high standard. So beyond all reasonable doubt, we could talk forever about what that means. We'll delve into it another day, but just giving you an idea. Beyond all reasonable doubt. That's always the question. It's like, do you feel like it had been proved, all the facts have been proven beyond that this person murdered this person beyond all reasonable doubt? That means reasonable doubt, not crazy doubts, not like, oh, well, you know what? I'm pretty sure. I was about to jump to the allegations of like a UFO came and did it, but you can't even say that anymore. Even if you tried to say, you can go, yeah, it's a possibility a UFO may have done it. Like, could have been, yeah, absolutely. I don't even know. I mean, no. It's hard to give an example. It's like magic. It's like, no, that didn't happen. It was because of magic. That's not reasonable to a jury. So it's got to be beyond all reasonable doubt. Now, in a civil trial, the burden really looks like this. It's like, is it more likely than not? And the way we like to argue it, as we used to say, is like, we'd always tell a jury this. In a criminal trial, if you put the evidence on a scale, it should literally tip to one side or the other. Super high.
So like, it's more like a persuasive game.
Yeah. Yep. Okay. How confident is the jury in answering these questions if this person's guilty or not? So in a criminal trial, it needs to be super weighted in one side. Like, if you're going to find someone guilty of murder, you better have so much evidence. It better be so clear. You've got no questions. All the jury members sitting back there going, this is clear. I've got no doubt, no reasonable doubt. By the way, you can have a little bit of doubt. It's got to be reasonable though. So beyond all reasonable doubt, the evidence is so skewed in one side or the other. In a civil trial, it is not like that. In a civil trial, we look at it like a scale and we say, if we put all of the evidence together, all that needs to happen for you to find one side liable or guilty, technically liable, but people always confuse the words, is for the scale to shift just a scintilla. That's what we like to say, scintilla in one direction. Yeah, it's a good word. It's a good word. It's a good word that any legal professional will tell you. It's scintilla of evidence, which is funny because we try to leave those type of words out from the jury, but it is such a, yeah. So we say the greater weight of the evidence, a scintilla. So which means it only has to shift slightly in one direction for you to go, oh, that guy's liable. But in a criminal trial, it needs to be so shifted to where you go, that guy's guilty. Like, it has to be, it's a higher burden.
And do you think that just because in our society, like, obviously a human life's like,
oh yeah,
going into jail is more like weighed heavily than like the money you owe to someone.
Yeah.
Like a civil versus criminal.
Absolutely. Think about, in a criminal, we're talking about murdering somebody, like execution style. Which we should talk about, that new execution that they just did, that gas that went all horribly wrong, it sounded like. But yeah, so that's really the difference between those two things. That really is what we're looking at, the burden. So in a lot of times what you'll see sometimes is that if someone's been charged criminally and then later on they want to sue them, the O.J. Simpson's one of the biggest trials when you think about that. But if the criminal trial's already been done and that person's been found guilty, in the civil trial, it is admissible to bring in the fact that he's been found guilty by this trial, the criminal trial. So it does become admissible, and you are allowed to use it because you've got a guilty verdict depending on what the allegations were. Okay, so let's get into the Maya Kowalski and talk about what the charges were, which were really interesting. This is one of those really interesting cases where the charges were just very unique, because that's sometimes what happens. Sometimes something takes place and you're like, I know something wrong happened here, but what is the cause of actions, right? What are you gonna sue them for? What's the name of those causes of actions? We say causes of actions are like battery, are like negligence, are like theft. Those are called causes of actions. And then you got to figure out, can you prove all the elements? So the background story to Maya Kowalski, just kind of walking us back through kind of what we had already talked about, is that Maya Kowalski was a young girl. I think all of her pain started about 10 years old, and she was diagnosed with CRPS, complex regional pain syndrome. And Darby gave us a little bit of background with what regards to that is, which is like extensive pain.
Yeah, like what feels like a feather to us is a stabbing knife pain to them.
Yeah.
Like it's your mind not realizing that you will get over this, like your body is self-soothing, like it'll get over this wound.
Oh gosh.
It just thinks like the mind tricks itself into thinking it's just going to get worse.
Yeah. It's
going to get more painful. And that's what happens to the human, like their mind when they get this disease.
And she was 10 years old. So she's 10 years old and she has insane amounts of pain. And So then what takes place is that her parents are doing everything they can to try to figure it out, because it also is very rare, right? And very rare in children, from what we ended up finding out later on, was that. So that's why nobody could figure it out. So they did all this research. They figure out that that's what it is. But it really is one of those, and I always kind of go back to this thing, is that when you can't find an answer, you're really looking anywhere, and you find side doctors. You find doctors in other countries. So they figured out the best treatment was from the doctors that they were seeing, not from a major hospital, that ketamine was the drug that was really going to be her best bet. So they do a whole they take her to another country, and they do a 5-day coma of ketamine, which ends up making her better. She's better for a while. In October 2016, she relapses and she's sick again. They take her to Johns Hopkins All Children's Hospital in St. Petersburg. It's right here up the street. And when they go in, what really sparked kind of the hospital to really start asking questions was Maya Kowalski's mom, Beata Kowalski, who was very, very involved, who happens to be a nurse. Oh, I have goosebumps every time I talk about it. A nurse, Polish, and we talked about this last time too. It's just like, that is such a, when you've got that, the ethnicity difference, people just are quick to judge you. And like we were talking about Mary, my accountant, who's phenomenal, who's Bosnia, who is easily misunderstood, but also very passionate and right to the point. And those people, just like her, I always think of Mary to me, is because she is a mother bear that will do anything for her children. And when you are now thinking about the life of your child and like, oh my gosh, everything's riding on making sure she has the right treatment, she went into that hospital already knowing, I'm a nurse, but I'm also a mama crazy bear. So she tries to explain it to the hospital that, hey, this is how much ketamine she needs. We've been doing it. Here's what she needs. So that already puts them on defense. They're just like, wait, this lady's coming in here talking about we should inject her daughter with all this crazy amounts of drugs, of street drugs that they're acting like, because they also are being used as street drugs. And that raised all these alarms. While the mom is going, my daughter needs this because she's in pain and she has to have it. So she's also getting more agitated. I mean, like every time I think about the story, I know exactly what it looks like. I know what it sounds like. I know what it feels like. It's like I've seen it before, and it's like a train that you just knew was going to derail because of all it was like the perfect unfortunate disaster, because you're dealing with her over emotions. She's a fearful mom. She's very direct to the point, and now you've got a hospital who's already on the defense because she comes in wanting all these drugs. So they immediately get social services involved. They do an investigation. They decide very quickly within 3 days that they think that Beata is abusing this child, that she has Munchausen syndrome, where she is creating these false illnesses in order to over-medicate their child. There's a whole background on why people believe that takes place, as parents do it for the attention. Parents do it to feel like they've got control over their child, all of these different things. So they accuse her of that. They keep the daughter in the hospital. They issue a no contact order really quickly. The mother can't see the child. The father can't see the child. They have a brother. And at 87 days of after 87 days of Beata Kowalski not being able to see her daughter, she commits suicide on January 18th, 2017. And we talked about that when we read her letter, which was insanely emotional. My heart goes out to not just this family, but my heart goes out to any family that has ever been accused of this, have ever felt that defensiveness of what it's like to be a mother or a father protecting your child, and then to be accused of this, and ever having to deal with the social services system. And my heart also goes out to the system trying to protect the children. It is a hard place to be for both parties. And although this takes place, we don't look at any blame and say this is always what happens at hospitals or always what happens with the social services. So unfortunately, and I was reading some of what took place during the trial, and we're going to go over what the causes of actions are. So eventually they do release Maya back into the custody of her father, and they start to determine that obviously something went wrong, and they start meeting with lawyers to figure out what are the causes of actions here. And so these end up being, they find a team of attorneys that end up taking this case, and here is what they sue the hospital for. They sue that what they end up finding the hospital ends up being found guilty for false imprisonment, battery, medical negligence, fraudulent billing, intentional infliction of emotional distress, as well as a survivor claim for intentional infliction of emotional distress, wrongful death claim for intentional infliction of emotional distress. I think that's and I will always preference, if there's something we kind of get off when we're researching, we may have some of our facts potentially a little skewed. So I guess there's a disclaimer for that. If you have any questions, please reach out to us, or if you find anything on the internet that's different than what we say, that's a possibility. But we're giving you the best information that we have at our fingertips. And so the jury came back and awarded the family $261 million. And when I was doing a bunch of research, what I thought was beautiful about some of the stuff that was said was that the jury really felt, there was people of the jury who just really felt, and from Maya Kowalski's perspective, was that her main motivation for this case was not money. And nobody can think that there's not an amount of money that's ever going to bring back a mother. And Maya testified on the stand that she had no idea that the last day that she had seen her mom was when she said bye to her mom, and had no idea they were taking her mom from her and was not going to let her mom come back. But that was going to be the last day she was ever going to see her mom. And she found out by herself while she was sitting in a hospital bed when she couldn't see her family that her mom had died. And she said that she really felt like it was so important for the world to know that her mom had not done these things that she had been accused of. Although she hadn't been charged, when mom hadn't been charged, her mom committed suicide before any of that stuff took place. But these allegations were out there against her mom. And that was a huge thing for the whole entire family, to just have that justice for the mom, to show that it was the hospital who did things wrong. And they absolutely have achieved that. I mean, especially through Netflix's documentary, The Whole World Is Watching Now. So let's go over what some of those look like, because that's really kind of, it was very, very interesting with kind of how they broke it up. False imprisonment. So false imprisonment occurs when a person intentionally restricts another person's freedom of movement unlawfully. I mean, a hospital being charged with false imprisonment.
I mean, it's kind of nuts when you think about it. I mean, they were denied. Like they said, when they tried to leave, the hospital said they were going to get security. That's
exactly the facts that the jury said were the reason why they found them guilty of it. Yeah. They believe that because, now remember, if it was determined that the hospital had just right to do that, if they had all of the evidence they needed in order to determine that, then it wouldn't have been considered false imprisonment. So we're going to go over some more of those causes of action that we're talking about right after a break. Back to Legal Candy. So we're talking about the causes of action that Maya Kowalski's family brought against, which means to sue, the Johns Hopkins Hospital. So we just talked about the false imprisonment. And you just hit the nail right on the head. That's exactly what the jury said, is that because the hospital said, so as soon as Beata and I guess the family realized that Johns Hopkins was not going to treat their daughter in the form of treatment that she believed needed to be done, because she's not only a nurse, but they've already been doing this for years with their daughter. And so they said, well, we'll take her from there. And they said, if you take Maya, we will have security stop you. And that ended up being determined to be the elements of false imprisonment. And so had it been determined that the first thing the jury had to even look at when they're doing an analysis for these causes of action was to determine the ultimate actions that the hospital took. Were they justified? Did they have the right facts behind them in order to do all that stuff? Because had there been a quick investigation done, like they did when they came in and they called social services and were like, hey, knock, 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 we think that there's abuse happening here. Do an investigation real quick, because it does happen a lot, especially in an emergency room, because you've got a small amount of time in a window to determine if you have enough facts to do an emergency shelter hearing, because if not, you got to release the child. You can't just keep the child there. It's just like a criminal case. If you're going to potentially if an officer comes into contact with you and he decides that he wants to try to investigate to figure out if you committed a crime, he's got a small amount of window before he has to either let you go or charge you. Because if not, he could be found liable for false imprisonment. Can't just hold you there and go, well, I don't have enough here. That becomes a violation of your constitutional rights. So it's the same thing kind of here, is that if they had done the investigation and they had the right evidence, the verifiable evidence, and that a jury had believed that they were correct, that Beata was suffering from Munchausen syndrome and that she was potentially abusing this child, had there been enough evidence there in that small amount of window, I think the 3 days, if the jury believed that, then these causes of actions, a lot of them wouldn't have taken place. So it's the fact that the hospital did not have justification. They believed that there wasn't enough evidence. They believed that had the investigation been done properly, they believe that the woman, Kathy, I think was her name, Kathy we found out, was not a public social worker. She was they were privatized, and that she may have had it out for, who knows, I think maybe an ego, but she ignored the most important evidence, which was Maya Kowalski's former doctor, or her current doctor, who didn't work at the hospital, who had actually diagnosed, and the one who was part of determining the ketamine dosage that she was getting. So had they included that in the report, which she should have because she talked to him, for some reason she didn't include it, it would have changed the whole thing. The hospital they wouldn't have been determined by the court systems that quickly that they believed that this mother was committing abuse. So that was one of the causes of actions that I found was just probably the most interesting I've never seen before, but I've felt it before. I mean, I've seen it before where you've been in a hospital where they've said something needs to happen and you've got to stay and get this done, and you've questioned, well, can I just leave? Like, you've seen people say that. Well, can I just go? Am I allowed to go? Yeah, you're allowed to leave. You're not being held there against your will, except in situations like this, where they believe that it could potentially be abuse. Okay, so then we had the intentional infliction of emotional distress, and that's another one that wouldn't have been charged. So the elements of that are that the defendant must have intentionally engaged in the conduct. The conduct must go beyond the bounds of decency. The defendant's conduct must be the cause of severe emotional distress. And so when you're looking at that and you're going, well, did the actions taken by the hospital, such as reporting Beata for child abuse, was that potentially offensive in a way that caused this kind of extreme emotional distress on Maya Kowalski? And I honestly think now that we know, of course. I mean, what is more emotional distressing than to be alleged that you have abused the child, that you have done everything to make sure she is safe, out of pain, and protected?
It's detrimental.
So traumatizing. I mean, so traumatizing. And so they've definitely found them guilty on the emotional distress. And there's a survivor's element of it too, is that when you're looking at who else has a claim of emotional distress against something like a hospital? The daughter, who loses her mother, the husband, who loses his wife, the brother who loses his mother. I mean, those are all people. Those are called survivor claims. The people who have survived this, who were in some form or fashion dependent upon that person, gets to now also sue the person who's responsible for that. Those are survivor causes of actions.
Now, with those claims, though, for emotional distress, I mean, how are damages determined when it comes to emotional? Like, I get people ask me that all the time. They're like, how are people awarded $50 million because you say you lost consortium with your wife? Or like, how do you determine that?
Yeah. So we've got several different types of damages. So we talked about here when the jury awarded damages, they awarded damages for potentially compensation, but really, and we'll go back to kind of what some of those numbers were, if I remember, is when they broke them down that. So when you just talked about the consortium, so the highest amount the jury awarded in the total sum was $50 million to Jack Kowalski for damages he sustained for the loss of his wife's companionship. That's a consortium. Protection and for his pain and suffering as a result of Beata. How does a jury determine it? So if you're doing actual damages, compensatory damages, those are type of damages that a jury's going, These are actual damages. You're in a car accident, your car was damaged, you have these actual surgeries that have to happen. Those are actual damages. Now, something called punitive damages is to punish. Now, on an emotional distress claim, those damages are going to be, what does a jury feel that is a number that they believe that will potentially compensate you for how severity that distress was? And I can start by telling you, you don't want to be on the other side of a jury who has found you guilty of causing someone emotional distress and then trying to put a price on it. Because juries go make up numbers. Sometimes you hear numbers and you want to know if a jury had ever managed a checkbook, because you're going, what, $150 million? But that's what a jury gets to do. A jury gets to decide what they believe the numbers are. And that's why you see sometimes on appeal, or potentially we were talking about before, where there'll be a reduction in those numbers, where an appeal court goes, well, we don't think that's really reasonable. Those numbers seem a little crazy.
That's where you hear the word like remeter.
Yes. Like, okay. Yep. That's when the number gets reduced, which ended up happening here.
Is that when they think it's too excessive?
Yeah. They think it doesn't, where there is an unrealistic, unreasonable correlation between the damages and the amount that's awarded.
I think it's also like a good side note. This is really important why venue is so important, because that's when you're choosing your jury selection. And then that's the difference between having jurors who are like $100,000 is so much, and then you have a case like this where they're like, yeah, I think 50 million is appropriate.
Oh, I never thought about that. I never thought about that for jury venue. That's a good point. We talked about jury venue in the idea of like that becomes a big fight of where should this be tried, because we want juries who don't know about this case, right? Because we do know that people who were here in St. Petersburg, Clearwater, had heard about that because it made local news, but it wasn't international news when it took place. So when you're doing a jury here, they're more likely going to know the facts or whatever they've heard, which could make them biased. And so I never thought about venue being like that. Like, are you in a small town where they think a small amount of money is a lot, or are you somewhere different? Because what first came to my mind was in New York City, where one of those cases that was, they accused a woman or man, I think it was, I can't remember who it was, of shoplifting. He goes outside of like Bergdorf's and he starts walking down the street, and the security chases him down and like jumps on this, I think it's a woman, jumps on this woman's back. She like falls down, and they think that she was stealing, and they bring her back. They take her into the back. They make her, I think they maybe make her show that she's stolen or not. And she hadn't stolen anything. But they embarrassed her, right? They embarrassed her. Her actual damage, I think she like scraped her arm or something. I don't remember the facts, so don't quote me on it. But I think she like scraped her arm. But I think if I remember, the jury awarded in punitive damages, like $150 million, right? And then in emotional stress, something else. Like these numbers. So when I thought about venue, I was like, well, in New York, $100 million isn't going to get you all that far sometimes. So, you know what I mean? Depending on who was on that jury is going, well, I don't really know. I mean,
imagine having it in like Missouri or something where the cost of living is so much lower than something like New York City. So I think that's why it's important for the public to know that that's where some of these crazy numbers are coming from. I think the Kowalskis did a good job in like picking their jury pool.
Yep. And so when it potentially gets overturned with it being unreasonable, is because there's no correlation. So to give you an example, like the McDonald's case. On the McDonald's case, when they did, we should do a whole entire thing on the McDonald's case, on the hot coffee. Because if you knew the facts of the hot coffee case, you wouldn't just think that hot coffee spilled on this old lady's lap and she got a bunch of money. No, this was scalding hot coffee. It was unreasonably hot. They've been told to not make it that hot, and not only did it fall on her lap, it caused the worst burns you ever could see in the middle of this lady's lap, this old lady's lap.
Elderly lady.
She was super healthy afterwards. I think she had 17 surgeries, and she ends up dying a couple years later. I mean, it was a horrific outcome. But the damages that they awarded there were punitive, which were high. But when it came down to being questioned, was this unreasonable? The jury ended up kind of doing an analysis that they believe the way that they did it was that they determined, they almost charged them as punishment damages how much money McDonald's makes in coffee in one day in all of their stores. That's what came out to I think it was like, I can't remember, millions and millions of dollars. $20 million, something like that, 25 million, whatever it was. So that would be not unreasonable. If there's a correlation of where it comes from, it's not just a made up number. So that's what you're looking for a lot.
So punitive damages sends a message, basically, because it's
Message.
more than just actual damages. What do you think this sent to the hospital? What message did that give to the hospital?
It sent the question and it'll wake them up and every hospital up. Now, why I love the fact that Netflix has done the documentary is that it really will change the analysis between the medical sector versus what the parents' rights are. That's what's really going to happen, to where it's going to, I have goosebumps thinking about it, because you hate that something like this is what's going to have to wake up people and say, knock, knock, you need to pay more attention and be careful what you're doing, because these are people's lives. I think I may have told you is that what I've done so many different areas of law, thanks to Luke LaRoe, back in the day when I first started, and we just did civil rights, we did all kinds of different stuff. But we did, anything that would come in, I'd be like, I'm going to learn it and I'll represent you. So I did a lot of stuff where I was really looking into and representing people who had been in trouble with looking at what's going on with their children or any of that kind of stuff, like child protective rights. So I've seen the system from the inside, and it is very unfair a lot of times. And it's a hard balance to make between the child's rights and the parents' rights. But now if you add this other element of the medical rights, and now all of a sudden, how do we better protect the children, the parents, and the hospital who's trying to do the best thing they can for everybody involved? Do we change what the standard is? Do we change the way we do an investigation? Do we add more levels of protection? Do we err on the side of saying, you know what? Instead of issuing an emergency order where we keep a child who's 10 years old in a hospital by herself away from her entire family, do we look at that again? Because that was kind of one of the biggest issues of why I think, and I hate to even go back to why of the suicide and make answers for Maya Kowalski, but I know people ask and wonder, I can't believe she committed suicide, and how did she think that was helping her child? And I want to say that I understand in the weirdest way as a mother, because what ended up happening for her that I've seen before was that they were not going to release Maya to the father. And they even said, Maya's mother said, I will leave the house. I will not be anywhere near them. And the court said no. And let me tell you why the court would have said no, and why I know they would have said no, is because I've seen this happen before. Because they don't believe it. They don't, and it would be almost ignorant of a judge to think that was going to happen. You know, even if you say, yeah, I'll move out, guess what? She'll move out and talk to her and show up. So I know it was really hard of the decisions that were made by the hospital, but that's what you hope happens from something like this. And I know it will. I know it will. It'll change the system to where this unfortunate situation, to where a mother believed that the only way she could help her child was to commit suicide, because they were not going to release the child, and they believed if they didn't release her from Johns Hopkins, that she was going to potentially continue to get sick and unfortunately die. That is what that's what Maya's mother believed. I believe that she believed in that moment, and that's what happened. After she unfortunately committed suicide, they then released Maya to her parents, and she was able to get the help that she needed. So we are out of time. I don't know how this happens, but we are out of time. And I know we have just, like I said before, my heart goes out to this family, any other family that's been in that situation, and the hospital. You know, it is so hard to be in the position that the hospital's in. And I have such a great amount of respect for doctors, nurses, social workers, because they are these unsung heroes a lot of the times, but there are instances that it can go wrong, very wrong. And that's what happened here. So we just hope that the system puts those protections in place to where what happens to this family will never happen to any other family, because I know that was not the intentions. I know everybody, I believe everybody, maybe except Kathy. I don't know about Kathy. Kathy, I have a question, Kathy. But
99%, everyone woke up that day and did not intend for this to happen.
Nobody intended for that to happen. Nobody did. So, like we always said, we will figure out our next topic. Anything else comes up, if you have any topics you want to hear about, just let us know. And Darby, thank you for all of your questions and your legal insight.
I enjoy this time so much. So really, it's just a pleasure.
Good. You do, learning and being able to spit all the information you learned from law school.
Yeah. And I think it's also important that you get a public, because as I'm learning, it kind of helps me get a realistic view of what the public doesn't understand about how you can break down law and make it more digestible and palatable.
Which is the goal of Legal Candy. Tune in for us next week. Thank you very much for everything that you guys have done. The questions, I hope you've got, let us know if you have any other questions, and we will see you next week.